right, we're going live.
We're on YouTube.
Why? Because security's only letting defendants into the courthouse because of the window. Once people are here in case something happens to them.
Hey, how are you?
So we're gonna turn the video to an NFT and then we're gonna video. Blank or just a blank sign.
Yeah. Well, let me just a few more points. It's kind of like that. I've read it.
Yeah.
Kind of like wrap it up. Let's move on.
That's kind of what I had understood to say. Who was it?
I've never seen it. Terry suing on behalf of a client that they're arguing about. Where does appear for the whole person?
I'm going to appear as soon as we're done here.
Sure.
Yep. I'm gonna work till 10 o'clock tonight.
You on the 17 and under or over?
I can work anywhere.
Coworkers.
'Cause I did all the training, I did everything.
Six freaking.
But, Really don't want to work on with the 17 and under. I don't want to work.
It was like a hack.
What do you do? Just foot patrol?
Yep, I'll be out on the yard today. And by the time I get there,
Seeing over one's.
I'll be running child lines. The child lines are done and the yard will be closed. So I'll just go sit in the unit and go talk to somebody I know.
Really, I recall it was like a really, really scary act down here.
Yeah, anything happens. Yeah, exactly. Probably have to do zones.
What do you wear when you're out?
They gave us uniforms. Yep. They gave us uniforms and they even gave us a pair of Rocky boots. But I had my own boots. I bought when I worked inside last year. And I like them a lot better than the Rockies that they gave me, so I just wear those. But yeah, they gave us uniforms. And, everything, like they gave us winter coat, spring coat, rain gear, sweater. They gave us a pick of shirt, so I got 2 long sleeve shirts. Not even thinking that I'm probably gonna need a short sleeve one for the summer. So I'm gonna see if I can order like 2 short sleeve shirts and pants, belt. I mean, they even gave us utility belts and they gave us everything.
So you're gonna be strictly working with peers for you?
I'm scheduled to work both, but Saginaw got 11 OJTs. So, and I think when they come back, they're gonna be able to go on shift, so.
11 OJTs, which means they're already certified corrections officers.
Yeah.
Came from another facility.
No, they just got out of the academy. They just
Oh,
got out of the academy and so, and they can go, but they can't work overtime. They can just go and work their
that's
shift.
right, contractual, they can.
So they can
What is
just
it,
go.
60 or 90 days?
No, it's, I don't know what it is now. I think they're waiving it after 6 months.
They should waive it a lot sooner.
Well, for us, it was a year. For us, we had to wear the goofy red tag
Yeah,
for
we're
a
60
year.
days.
And then, but now because they're so short,
60 days, but we're not gonna block you out of that week.
you know, and then I was just talking to, they had a Senate hearing on everything that's going on with the DOC, and they're like, you know, what's your issue? And, you know, they're like, the issue is they don't offer nothing no more, so nobody wants to work for them.
Yep.
And then they were like, well, we got 200 people in the academy coming into the prisons. They said, by the time those 200 people are able to work by themselves, they'll have 300 people quit.
Right. And out of that 200, only 80 of them are gonna make it, because you're gonna have about 120 of them drop out and say,
Right.
"That's exactly what the job is."
Yep.
It's a difficult process, that's for sure.
They can easily resolve this issue. All they gotta do is bring back the pension, and bring back healthcare, and you can pick and choose who you wanna work inside.
Yep. That's everywhere though.
Yeah.
It's across the whole state.
It's everywhere. But I don't understand
Our
how,
units too.
I don't understand how the state of Michigan can go, oh, we're not gonna do this and this, and we're just not gonna work. The biggest hiring entity in the state.
But it's legislative working on lesser and lesser prison terms.
Pretty soon it's gonna be. Okay, all done, okay. Hey, you can come pick me up now. Yeah, I walked inside. I see what it looks like in there.
It's going that way now. As it get sentenced to 12 months. 12 months to finish up. They're only in there for the quarantine. But yeah, that's the check.
Please be seated. This is a matter of the people of the state of Michigan versus Noah Martin. There are two files. One is 21-15419, and the other is 18-14664 FH. The first file I indicated, as I understand it, there is a bench warrant hearing, as on the second file. What's your understanding, counsel?
Yeah, sure.
Yeah.
We're here to resolve both those files today.
Are your appearances for the record, counsel?
Eric and host on behalf of people.
Good afternoon, Eric. Wayne Purchase on behalf of Mr. Noah Martin.
All right. What's the status of these matters?
Here, in regards to the 18 file, that's a probation violation. Mr. Martin is here to enter a guilty plea to the violation from back on April 22 of 21. That is that he failed to report. We had a discussion with Judge Gierhart. There's a cops agreement in that file that guilty plea is going to result in a revocation of his probation, and he'll get credit for time served. And then the other probation violations will be dismissed.
One on the 21 file.
On the, yes, all the other probation violations, there's a more recent probation violation in that file, that'd be dismissed as well. And then that resolves the probation file, and we've got a resolution on the 21 case as well.
Okay.
And that's a case that's still, there hadn't been a plea yet. Mr. Martin would offer a no contest plea to count one larceny in a building with 3 prior felonies. No contest plea is to avoid civil liability. Factual basis of a police report, which has been submitted to the court. In exchange for that, count 2 would be dismissed. There'd be no other additional charges from property taken from TI Automotive that were in that police report. And in that file also, there's a cops agreement, no jail, no probation, fines and costs only.
What's your understanding, Mr. Hinojosa?
That's my understanding on both files, Your Honor.
So, okay, here we are. Let's do the 21 file first. Please raise your right hand to be sworn. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
What is your name?
Noah Lee Martin.
And Mr. Burgess is here representing you, is that correct?
Correct.
Can you read, write, and understand the English language?
Yes, sir.
Can you hear and understand me here this afternoon?
Yes, sir.
And have you been able to hear and understand Mr. Burgess when he's discussed this case with you?
Yes, sir.
Have you had a full and complete opportunity to consult with him about this case before coming into court?
Yes, sir.
Are you satisfied with Mr. Burgess's representation of you?
Yes, sir.
Did you understand the plea agreement and the sentence agreement that was entered into in this matter?
Yes, sir.
Are you agreeable with it?
Yes, sir.
Have the attorneys placed the whole agreement on the record as far as you know?
Yes, sir.
And are you asking the court to accept that plea agreement and sentence agreement?
Yes, sir.
Are you currently on probation or parole for any other offense?
No.
Is he on the 18 month?
Oh, yeah, he's on probation.
Well, I mean, for another-
From the other file, this was the new file, but you're already on probation on the 18th file.
Yes.
So you're on the 18 file, but there's already been an agreement placed on the record for what will happen to you about that, right?
Yes.
So there's an agreement in this new file that you will be pleading no contest to count one, which is larceny in a building, together with 3 prior felonies, which makes this an habitual offender, 4th offense. You understand that?
Yes, sir.
And that has the effect of making the maximum 15 years in prison. You understand that?
Yes, sir.
So with all this in mind, how do you wish to plead to this charge of larceny in a building, 4th offender notice?
No contest.
You've had an opportunity to read and review an advice of rights form in this matter, is that correct?
Yes.
You understand that those are the rights that you would have at a trial.
Yes, sir.
And when you plead guilty, if the court or no contest, if the court accepts your plea, you will not have a trial of any kind. You understand that?
Yes, sir.
So you're giving up all these rights that you would have at a trial. You understand that?
Yes, sir.
You understand that you give up any claim that your plea was a result of promises or threats, unless you tell me about those now.
Yes, sir.
You also give up any claim that this was not your own free choice, unless you tell me that now.
Yes, sir.
You understand that if the court cannot follow the sentence disposition agreement, you'd be allowed to withdraw your plea of guilt of no contest.
Yes, sir.
And you understand that for purposes of sentencing, the court will be treating you as though you were found guilty of this offense.
Yes, sir.
Other than what has been said in court today, has anyone promised you anything to get you to plead no contest?
No, sir.
Are you pleading no contest freely and voluntarily?
Yes, sir.
Has anyone threatened you in any way to get you to do so?
No, sir.
You're agreeable with a no contest plea because of possible civil litigation, Mr. Hinojosa?
Yes.
Very well, the court finds that since these same facts would give rise to civil litigation, a no contest plea is appropriate. I will review a portion of the Cass City Police Department's police report, being incident number 20-001-386. All right, I reviewed that information. If taken at face value, it would appear to satisfy the elements of the charged offense. Do you agree, Mr. Prosecutor?
I do.
And Mr. Burgess, do you agree?
Yes, Your Honor.
And does it appear the court has complied with the court rules regarding the taking of no contest, please?
Yes, you have, Your Honor.
Yes, Your Honor.
Very well, I'm now convinced that the plea of no contest made is accurate, understanding, and voluntary. I'm also satisfied there is a factual basis to support a finding that the defendant is guilty of this offense. I will therefore accept your plea of no contest and order it entered upon the records of this court. Your case, since it's fine and cost only, does the judge always send this for a pre-sentence report? You're supposed to, really, I think.
I think normally she does because it's a felony,
Right.
but I would request that you consider reducing a bond to a PR bond as much as there's not gonna be more jail time involved.
All right. Well, first of all, I'll refer this to the probation department for an investigation recommendation in regard to sentence, and you'll be notified of the date of sentencing. You have a motion on bond, Mr. Burgess?
Yes, Your Honor. Your Honor, like I said, both these cases are gonna result with no jail, no probation. So we would, Mr. Martin has a place to stay, basically, so we're gonna come back in 3 or 4 weeks for sentencing. I'd ask that you consider releasing him on a PR bond so he can come back for sentencing later.
Counsel?
In light of the plea agreement, I believe it's your discretion.
Very well, bond was amended to a PR bond. Anything further on the 21 case?
Not on that case, Your Honor, no.
Okay. In regard to the 18 case, this is a probation allegation of a probation violation. Did you say this was the one dated April 22nd?
Yes,
Okay. So there's going to be a plea to count one, is it?
yes,
guess
I
that's
believe
all
there's
there
only
is.
one count now.
Yeah. Failed to report. Okay. All right, you're still under oath, sir. So, Mr. Martin, you understand what the allegation is by your probation officer, Jerry Zajac?
Yes, sir.
He alleges that you failed to report on your regular day of April 15th of 2021 and had not made any contact with him to reschedule as of April 22nd of 2021. You've had an opportunity to discuss this matter with your attorney,
Yes, sir.
and how do you wish to plead?
Guilty on
What makes you guilty?
failure to report.
Pardon?
Failure to report.
So you didn't report?
No.
You knew you were supposed to?
Yes, sir.
Why didn't you?
Because of those other charges, and it's just out of fear.
You thought you'd stay away from this place.
Yeah, I guess.
Okay, I'll accept your plea of violating your probation by not reporting on April 15th, 2021, or anytime thereafter. I will order that entered upon the records. This court, I find it's knowingly, intelligently, and voluntarily made with the advice and assistance of counsel. The agreement for sentence is probation. There appears to be no fines and costs on this one. I don't think, just probation revocation.
Whatever sanctions, there would be no additional sanctions other than
All
credit
right.
time, sir.
That's your understanding?
Yes.
I think I'll just sentence him then. It shall be the sentence of this court for violating your probation, that your probation is revoked without improvement. You have whatever time you have in jail, that's what your sentence is, with credit for time served. There will be no other probation violation charges pursued at this time.
Thank you, Judge.
Anything further?
No.
Okay, good luck to you, sir.
Thank you. Alan.
Next, he doesn't need a bond on the bench warrant because it's sensitive.
Not on the 18 file, on the 21 file. The file that was on the 18 file.
I just made that PR on the 21 file.
So, because there was a PR bond, it was canceled, so you want to just rewrite a bond?
I don't know why he was in jail. Supposed to ready the other.
You want me to?
Where's Mr. Burgess still in?
Just stepped out.
Can you get Mr. Burgess back in for a moment, please?
Court security, if you see Mr. Burgess, could you send him back to circuit court, please?
Do we just have to reinstate a PR bond then?
She says it already was a PR bond.
And it was canceled.
Okay. The PR bond that was canceled, so there was no bond on the file, so.
I mean,
Okay.
there would have been. PR bond.
Okay.
Do a bond for PR bond.
You need more paper.
No, can I get that one? That one I want to
Mr. Burgess, they tell me on the 21 file that they already had a PR bond that was canceled.
But it's already, so was it the bond on the bench warrant? You're talking the bench warrant for the PV? Because the PV he sent, the 2018 file print, and then there was a bond. That's 21 file.
Okay.
I reduced it to PR, but she says it already was PR.
Oh, okay.
Okay.
So I can rewrite them.
As long as he gets out of jail, I'm not sure how this.
So what do you want the amount to be?
$1,000 personal. response.
1,000?
He doesn't have to pay it.
And Ms. Beckman, I'll let Sergeant know that you're doing that paperwork that's gonna be for you, okay? Thank you. All right, let's go. We're all set. Thank you,
Okay.
Judge.
Thank you, Mr. Burgess. Ready on Hayward?
Yes. Court security, Friday's been run back to jail with
People versus John Hayward, file 21, 15476 FC. Your appearances for the record, counsel?
Eric and a host on behalf of people.
Good afternoon, Aaron. Dwayne Burgess on behalf of John Hayward.
Your name, sir?
John Hayward.
Right, Mr. Hayward, you understand why you're here today?
Yes.
You understand that you previously pled no contest to the charge of torturing an animal third degree.
Yeah, so my understanding that it was supposed to be a misdemeanor, not a felony for you.
Well, according to the report, is that correct, that he pled to a
Pled
4-year
guilty
felony?
to a felony, Your Honor, upon successful completion of a year delay, then it's gonna enter as a misdemeanor.
Yes. So if it's a successful completion of a 1-year delay of sentence, then it'll enter as a misdemeanor. So we're here today to decide on the terms of the 1-year delay of sentence. You understand that?
Yes.
Okay, and Mr. Burgess is here representing you, is that correct? Mr. Burgess, have you had an opportunity to review the pre-sentence report and recommendation and discuss it with your client?
I have, Your Honor.
Are there any factual inaccuracies you'd like to point out?
Your Honor, I have some, he does not agree with all the statements by the victim. And, you know, it's gonna be her side of the story and his side of the story, but I do want to point those out to the court. Somewhere within the report, she talks about he had shot his 15-year-old dog. He denies that. He says the dog died, but he did go out and bury the dog. Also,
But that dog is not what we're talking about here.
that's not this dog, that's correct. Also within the report, there's a reference where the probation officer, they had a discussion about the dog, and the discussion was, you're not gonna be able to own a dog during that 1 year, and he says, well, I already own a dog, what are you gonna do about that? But he called me the next day, called the probation officer, I understand, I apologize, he was upset. He does not own a dog now, he just said, I'd really like to own a dog, I mean, in his mind, but he does not own a dog now. There's also a statement from the victim, his ex-wife, that he shot at her beagles. Again, he denies that. He says there were times that the beagles were out in the backyard making so much noise barking at the deer that he would shoot out the back door to scare the deer away, but he certainly was not shooting at the beagles. So
Is this
those
the
would
dog,
be-
is this the dog that had the pellet in it?
No, there's a different dog.
Different
Again, the
dog.
beagles are outside dogs.
Okay,
So those are the only statements in regards to the report, but I do have more statements in regards to the sentence, Your Honor.
all right. Mr. Hinojosa, any corrections, deletions, additions you'd like to make to the report?
The only correction that I noted that Mr. Wanick had annotated on here is that the defendant had 11 prior misdemeanors rather than 10 on page 1 of the CFJ 145.
Any objection to that? Mr.
No,
Burgess?
Your Honor.
Okay, I'll change that to 11. All right, Mr. Burgess?
Your Honor, Mr. Hayward suffers from a number of medical issues. As you can see, he's in a wheelchair here today. He entered a no contest plea to resolve this matter. He thought at the time it was a fair resolution with a 1-year delay to be reduced to a misdemeanor. Does not admit that he shot the dog, but he understands that he's going to be sentenced based on that no contest plea. As a result of this action, I'm sure there was a whole lot more leading up to this action. His wife has filed for divorce. So now they're going through a divorce. Has sold the house, or gonna have to sell the house soon. Gonna have no place to live. He's got no income. He's applied for disability, still waiting for that. So he's got no income to live on. The only other concern he has, not only, but another concern he has was when he was out on bond, there was a condition of his bond that he not own any or possess any firearms. Well, his wife, ex-wife, called the police and said he's got guns upstairs. Well, she knew they were upstairs. He forgot they were upstairs. It was belonged to his father's guns. So he's requesting that those be returned. He understands the pellet guns can be forfeited, but those guns have nothing to do with this instance. So eventually those should come back to him. Term of his delay, maybe he not own or possess those, but he wants to pass those on to his daughter, their family property. Your Honor.
I take it his father's not around any longer?
No.
Right. Guidelines 0 to 3 months, no prior felonies. We'd ask you to follow the agreement, that is grant him the 1-year delay of sentence. Thank you.
Mr. Hinojosa?
Your Honor, I'd also ask that you follow the agreement. I would certainly object to the defendant retaining any firearms, pellet guns, or anything of that sort, given the nature of the offense that was articulated in the report. And I'd certainly ask that the court be sure to impose special condition 9.1, must not own or possess any animal. An individual who engaged in this sort of conduct has no business possessing any sort of animal or caring for any sort of animal.
Mr. Hayward, anything you'd like to say about your sentence before I decide?
No, I had a side business for raising pheasants and be able to sell pheasants, honey preserves and release them all around the state. I won't be able to raise pheasants now. And, you know, it's a side business.
So you're concerned about the provision that you're not to have any animals?
Yeah, I can't even have chickens to be able to gather eggs, to be able to feed myself.
What's your position on that, Mr. Prosecutor?
Your Honor, I don't think that the people can trust him at this point to treat any animals humanely, given the actions that he was he's here on, he shot defenseless animals with a pellet gun. Whether he would use that same sort of cruelty on pheasants or chickens, I think we can reasonably infer that any individual who would engage in this sort of conduct can't be trusted with, to treat those sort of animals humanely either.
Anyone else who wishes to be heard in this matter? No? Well, Mr. Hayward, I'd say it's a good thing you've got this agreement, because my biggest bugaboo is hurting other people, and my next one is harming defenseless animals, even though they might be obnoxious sometimes. They're animals, they don't know better. You pled no contest to this act, which was alleged that you shot the dog with a pellet gun. You know, there's even a statute now, which surprised me a couple of years ago, that says you can't even shoot your own dog. They amended that a few years ago. If your dog is, even if it's sick and ready to die, the statute technically says you can't shoot your own dog, which may be going a little too far. But this certainly wasn't the situation with this dog. So based upon the need to discipline you as a wrongdoer to protect society from these kinds of activities, and the need to deter you and others from committing these kinds of offenses, the terms of your 1-year delay of sentence are as follows. You're not to use or possess alcoholic beverages or other intoxicants. You're not to enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site. You are to comply with any request of your probation officer or any law enforcement officer for alcohol testing. You're to complete an outpatient or residential substance abuse treatment program if referred by your probation officer. You're to complete a substance abuse assessment if requested to do so. You are to complete the Thinking Matters program and waive confidentiality about any of the programs you're participating in, so that your probation officer can obtain information about your progress. You are to obey all court orders. You're not to engage in any assaultive, abusive, threatening, or intimidating behavior. You're not to use any object as a weapon. You're not to own, use, or have under your control or area of control a weapon of any type or any imitation weapon. Now, if you can show that, now we're not speaking about the ones involved in this incident, if you can show the other ones belong to family members, they can't go back to you, but upon proper presentation of verification of ownership, it can go back to some other family members if they would keep them in their possession. You can't have them in your possession. You are to contact your probation officer today. You are going to eliminate numbers 11 and 12. You're to comply with DNA testing and pay the $60 fee, pay $68 in state cost, crime victims' rights assessment of $130, pay $30 a month supervision fee, court costs of $300 at the rate of $25 a month, a fine of $200 at the rate of $17 a month, repay the county of Tuscola $500 towards your attorney fees at the rate of $42 a month. And you are not, while you're on this 1-year delay of sentence, you are not to own or possess any animals. Any questions about the delay of sentence?
After the 1 year, I'll be able to own firearms and be able to go hunting again.
That's possible, depending on what the statute says about what you did. I don't know. Some statutes, have a several-year requirement afterwards that you can't. I can't speak to that right now. But if you succeed on probation, you won't have any more probationary terms after 1 year.
Thank you, Judge.
Thank you.
People versus Brandon Goretsky. File 20-15326 FH. Your appearances for the record, counsel?
Eric and host on behalf of people.
Good afternoon, Aaron. Dwayne Burgess on behalf of Brandon Goretsky.
Your name, sir? Mr. Goretsky, do you understand why you're here today? You understand that you're here for a sentencing on a probation violation.
Correct.
And the probation violation is getting kicked out of the TRSC because of your conduct. Right? Is that correct? Okay, Mr. Burgess, have you had an opportunity to read and review the violation report?
Yes, Your Honor.
Are there any factual inaccuracies you wish to point out?
No,
Anything you'd like to say on behalf of your client in regard to his sentence?
yes, Your Honor. Brandon is employed at the Metamora Golf Course. He got behind his finances when he was laid off, and that led to him not doing the proper testing, and that led to him being kicked out of the sobriety court. But since that time, he's gotten his affairs in order. He can now afford whatever drug testing may be required of him. He attends weekly a group session at List Psychological. He attends individual counseling weekly at List. And we'd ask you to follow the recommendation within the report, that is continue him on probation and continue him on the scram tether. If for some reason, Your Honor, the court were to impose jail time, we would ask that he have a couple days and that he has some things to take care of home if he's going to jail. But we're asking that he not go to jail, but continue on the scram.
How much jail time has he spent in this case, none?
How much jail time you done so far?
No.
Prosecutor?
Your Honor, as far as corrections to the report, there's one very minor correction on the sentencing guidelines, the range. It said 7 to 23. I think it was previously decided that it's actually 7 to 28. So that minor correction to make, clerical error. We'd ask that you follow the recommendations of the MDOC in this matter.
Well, Mr. Goretsky, let's see, this is an OUIL third, which means you had at least two before this. You received the first 180-day sentence with 3 days credit, the balance deferred. Mr. Prosecutor, you're asking me to follow the no jail recommendation as well?
At this time, Your Honor, yes, I think we'll give him this one last chance to make sure that to try to follow through out of courtesy. Not, I think it would not be out of line to sentence him to jail, but I think giving him this one last chance to prove himself with the additional safeguard or the continued safeguards would be appropriate.
Mr. Goretsky, anything you'd like to say about your sentence before I decide?
I understand that, you know, looking at my record, I have had drinking problem in the past. I chose to quit drinking in 2018, and I had a few bad things happen. And I've been working on getting through like the triggers and everything. I didn't do it, and I never expected a passing of my daughter, and it was a bad trigger. And I've been working on it because I don't want anything to ever come across that triggers me to ever drink again. But I choose not to. I love myself without alcohol. And it's brought me too much risk and jeopardy of losing my life and others. So choose to continue not to drink and see that I'm sorry for this and won't let probation down. I'm finally back on track, so days away from work and everything really just set me back again. And I didn't get a job at the golf course. I was working on the golf course for the company I worked for, the company Custom Homes out of Metamora.
Did you say your daughter had passed away?
Yeah, and I had a year and a couple months sober, and then she passed away, and I relapsed.
Well, I'm very sorry about that. Nothing worse than can happen to anyone, I don't think, than have a child
Right.
die before they do. Normally, and I hope you thank your attorney and the prosecuting attorney for going to bat for you here on this, because normally a third offense drunk driver, if you give a chance to go to the court and they fail on that, then they get to serve their sentence that they would have had before that, 180 days. However, I know these two attorneys have looked at this situation and know more about the history of it than I do. So I have to take their advice pretty seriously. And I'm very sorry about your daughter. And I'm glad that you're on track, and I hope you can stay there. Because if you don't want to see guys like me in places like this all the time, that's what you have to do. So based on the need to discipline you as a wrongdoer to protect society from these kinds of activities, and the need to deter you and others from committing these kinds of offenses, but being hopeful that you have potential for reformation, rehabilitation, it shall be the sentence of this court that you be continued on probation and continued on scram for an additional 90 days. And you are to participate in random drug screening through a chance to change or another testing facility as approved by your probation officer. Any questions about the sentence?
Oh, thank you.
Oh, yeah.
Good luck to you, sir.
Thank you, guys.
People versus Richard Lanning, 21-15615 FH. The appearances for the record, counsel.
Eric Hinojosa on behalf of people.
Good afternoon, Your Honor. Dwayne Burgess on behalf of Richard Lanning.
Good afternoon. Your name, sir?
Richard Wayne Lanning.
All right. Mr. Lanning, do you understand why you're here today?
Yes, I do.
You understand that you previously pled guilty to two charges. One was possession of less than 25 grams of cocaine with an habitual fourth offender, which makes the maximum possible penalty 15 years in prison. The other was operating with the presence of a controlled substance, which is a 93-day misdemeanor. Understand that?
Yes, I do.
And you're here to be sentenced now on those two charges. You understand that?
Yes, I do.
And Mr. Burgess is here representing you. Is that correct?
That is correct.
Mr. Burgess, have you had an opportunity to read and review the pre-sentence report and recommendation and discuss it with your client?
I have, Your Honor.
Are there any factual inaccuracies you wish to point out?
No, but I did have a couple objections to the scoring.
Okay. Go for it.
Your Honor, OV 13 scored at 10 points. I believe that indicates he was charged a violation he wasn't charged with, the delivery type charge. He was charged with possession. I believe that should be scored at 0. And OV 15 is scored at 5 points, indicating delivery of marijuana. Again, he was charged not with delivery, but with possession of cocaine. I believe both those should be scored at 0.
Mr. Hinhausen, what about those two?
Your Honor, I'd agree on both of those. And I don't know if you want me to address the one objection that we'd filed as well.
Are you finished with yours, Mr. Burgess?
Yes.
Okay, yeah. Well, first, let me change these before I forget.
All right,
OV 13 will now be 0 instead of 10. OV 15 will now be 5, will now be 0 instead of 5. So that will reduce it by, so the OV total will be 0, right?
I believe so, yes.
Does that change? Okay, let's go on to yours.
Your Honor, my objection is the same that Mr. Wanek filed back on February 22nd. It's to PRV 5, which is currently scored at 2. It should be scored at 15 based on the prior record, and the list of convictions supporting that was in Mr. Wanek's objections filed with the court.
Mr. Burgess?
I would not disagree with that, Your Honor.
Okay, I'll change PRV 5 from 5 to 15. That will increase that by 13. So the total PRV would be 95, is that correct?
Yes,
And the OV is 0?
yes.
What level would that be?
The OV would be level 1, PRV would be remain at F.
Okay. And the range?
I had 2 to 34.
Yes, Your Honor.
Range 2 to 34. Okay. Anything you'd like to say on behalf of your client in regard to his sentence?
And I've submitted to the court that some letters. Hopefully the court has those in the
Yeah.
file.
Right, I do.
Okay. Your Honor, in speaking with Mr. Lanning throughout this case, he admits he's got a cocaine problem. He had a cocaine problem. He recognizes he'll always have a cocaine problem, but he had that problem under control. He lived up Grand Marais, which is, for us people down here, that's God's country. And he was doing very well up there, as you can see from the letters. He was thought very highly of up there. Was doing very well. He had supports in place. Just recently, the problem he ran into was he could not afford to go from Grand Marais to whatever town he had to go to for the drug testing. It was, where were you testing it in?
Unison,
Yeah, so from Grand Marais.
Unison, Michigan.
So the trip got to be, he just couldn't afford that kind of a trip anymore. So he moved back down here down to Warren, lives with, he's living back down here. He's also brought with him today a statement indicating, dated March 17 from D&H Asphalt Company, indicating that they in fact have hired him for the 2022 paving season. They'll run through April through Thanksgiving. So he's got employment. He recognizes, like I said, he recognizes the cocaine problem. As you read the incident report, it's kind of bizarre. He's down here visiting family. Trigger is he stops in Genesee County, which is never a good place to stop. He ends up buying cocaine and he ends up calling the police because then he has these paranoid delusions that the dealer's chasing him down. So that's what brought him to the police attention was he called the police. But he was able to get things cleaned up after that up in Grand Marais. Understand he has a terrible record, but he certainly seems to me when I talk to him that he's the kind of guy that should and could make it on probation if, as long as he's got those supports in place and he recognizes he needs those supports, Your Honor. Also. Yeah. And if you get a chance, you get a chance to talk to the judge about it. He has one other person with him, may want to talk as well, Judge, but like I said, because of the terrible record, the cops agreement was a 1-year cap. I mean, and then the judge says, well, we'll see how things sort out. And I would suggest to you that he is a person that can make it on probation without the need for additional jail time. And he does have he has some statements in regards to how he's been doing as well, Judge.
Anything you'd like to say about your sentence before I decide, sir?
Sure. I come to you this afternoon, Your Honor, with the Lord standing next to me. He's been with me since I was a kid. And I know I've been in a lot of trouble, caused a lot of trouble. I'm still staying and I'm still alive. And I don't know how sometimes. I thank this court for, me and my girlfriend had a fire a couple of weeks ago, and it burned down our apartment. And I had to call and ask for a waiver to get my sentence extended. So and I'm thankful for that it got extended. They spoke back and said, hey, it's okay, I'll give you a couple of weeks. So we're still dealing with the fire issue. We got burned out of our apartment.
Where is that?
That's in Warren.
Warren.
Yeah. My girlfriend's name is Debbie Randall. And she's sitting in the back. She came with me today. And I know I've caused a lot of trouble in the past. And my past is not good. But through it all, I managed to get through and come back out on top. I thank the Lord for everything, and I've been standing in this place a few times. And I've been going to timeout counseling, and before that I was up in the UP going to Great Lakes Recovery Counseling that I signed up for. And I've been going for the last almost 6 months now, testing twice a week for 6 months, and not without no dirty drops, or I've never missed, not one time. And I got my girlfriend Debbie. She's a great, wonderful lady. I've been alone for a lot of years, and me and her somehow met, and we both needed each other. And she's going to surgery at the end of this month, a soldier surgery, and she's going to need me, and I'm going to need her. And so I'm just asking the court to to give me probation and let me continue to go to counseling. I go to counseling every other week, and I do that timeout thing. I have to call on the telephone, and I test twice a week. So I'm paying for that, and it's been, shoot, I bet I've spent at least $8,000 in testing and gas on those two things in 6 months that I've been testing. At least $8,000. So and plus I'm willing to, I can pay off the fines and costs, and my probation fees and everything like that.
pay those today or you?
I could pay Friday. I didn't bring the money with me, but I can pay it.
Thank you. And ma'am, did you want to say something or not?
If I could, Your Honor.
You step up here because we have to record everything you say. Step right up to the podium. And first thing is tell me your name.
My name is Debbie Randall.
All right, where do you live?
I live in Warren, Michigan,
And you live with Mr.
at the
Lanning?
apartment,
Okay,
Williamsburg East.
okay. And you are Mr. Lanning's significant other, I take it?
Yes, correct.
And what would you like to say?
I'd like to say, since he's been with me, I don't pull no punches. I've never done anything like he's done, nothing. I fell in love with him. He's a very good-hearted man. He does anything that I need done, he's doing it for me because my arms are not working well right now. I have to have rotator cuff surgery. And he's been good. He goes to work every day, 6 days a week, and he comes home on time. He's really a good man. And we talk, and he needed a lot of love, a lot of patience. And I've been working with him, and he has no desire to go back to where he was. I'm very aware of his record. And I said, one time with me, one chance. That's it. And he knows that. And he's been very good. He's up every morning at 6:30, calling the counseling, calling his drops, making sure he does them all on time. I've had no problem with them. And that's what I wanted to tell you, Your Honor.
How long have you been together
We've been together since January.
this year?
Yes, that's correct.
All right, thank you.
Thank you.
Mr. Lanning, I think she might be a keeper.
She is.
Mr. Hinojosa, your position on sentencing?
Your Honor, this is a bizarre case. I'm kind of on the fence as to what to request here, because the defendant, as was noted, has an absolutely atrocious record and has a history of problems with the criminal justice system. I'm glad that he recognizes that he has a problem. I'm glad that he has taken steps to try to address that he is in counseling, that he's he's testing, that he's reportedly employed. At the same time, I think that somebody with his record should probably be serving some time here, but in the interest of being, in the interest of not upsetting what he has going right now, I guess I will make this compromise or this suggestion that the court follow the recommendations, but modify them slightly, that the defendant get 365 days deferred rather than the 180 days deferred, because if he screws up, I think he needs to have a very significant penalty hanging over his head. I think that based on this record, the court would be taking a chance on him. I'm hoping that the defendant recognizes that the court would be taking a chance on him and that he would not throw that away. But if he does, he should suffer the wrath.
Thank you. I think I'd have to have a stipulation from the defense because there's a sentence cap agreement of 180 up front. And if I don't follow that, he's got the right to set a decided plea if he wants. I think it is. Isn't it?
There's a 1-year cap.
1 year
And
cap,
it's-
I'm sorry.
And it's on the
Okay.
initial jail sentence, so if
Yes.
it was deferred,
Okay,
it would.
yeah, I'm corrected. Thank you. All right, anything further?
No, thank you.
Well, Mr. Lanning, I I'd say you certainly have impressed the probation officer. Because it doesn't happen very often that there's a 1-year cap and the probation officer is basically recommending no more time right now, no upfront time. So, and I look at the scoring process they have. Biggest risk is in substance abuse, which is no big surprise, is it? So, based upon the need to discipline you as a wrongdoer to protect society from these kinds of activities, and the need to deter you and others from committing these kinds of offenses, being hopeful that you have potential for reformation and rehabilitation, it shall be the sentence of this court on both counts that you be placed on 2 years probation with the following special conditions. First, you're not to use or possess any alcoholic beverages or other intoxicants, or enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site. Next, you're not to use or possess any controlled substances or have any drug paraphernalia. You're to have no prescription drugs unless prescribed for you by a licensed physician. And you're not to be in the presence of anyone else that has any of these items. You're to comply with any request of your probation officer or any law enforcement officer for drug or alcohol testing. You are to complete an outpatient or residential substance abuse treatment program if referred by your probation officer. You are to perform 360 hours of community service, complete the Thinking Matters or other cognitive restructuring program, and waive confidentiality about any program you're participating in so that your probation officer may know your progress. You're to obey all court orders, and you're not to have any contact with anyone you know to have a felony record without first requesting permission from your probation officer, especially no one you know to have a record of a controlled substance violation. You are to contact your probation officer no later than the first business day following, I guess that would be today. Allow your probation, I'm eliminating number 12 and 13. You are not to drive a motor vehicle while your license is suspended, and the Secretary of State will suspend your license. You are to serve jail time as follows. On count 1, 180 days, or 365 days, excuse me, in the Tuscola County Jail with 2 days credit for time served. The balance of the time is deferred pending successful completion of probation. As to count 2, you are to serve 93 days in the Tuscola County Jail with credit for 2 days you've served already. 91 days will be deferred pending successful completion of probation. Counts 1 and 2 sentences are served concurrent with each other. You're to comply with DNA testing and pay the $60 fee, pay $118 court costs, state costs, crime victims' rights assessment of $130, $30 a month oversight fee to the Department of Corrections, court costs of $500 at the rate of $21 a month, a fine of $350 at the rate of $15 a month, and repay the county of Tuscola $500 at the rate of $21 a month to reimburse for their attorney fees. Any question about the sentences?
No, thank you.
No, Your Honor.
My duty to inform you, Mr. Lanning, that you are entitled to the appellate review of your conviction and sentence. This is done by filing an application for leave to appeal. If you cannot afford to hire an attorney to represent you on appeal, and you request an attorney, the court will appoint an attorney at public expense to represent you. You may request an attorney by completing the request for appointment of attorney section on the form you will be given within 42 days from this sentencing date. Today, we just need the receipt from you that you received the document. All right? All right. Any questions about the sentence?
No, thank you.
And does the half reduction apply in this probation, do you think?
Let me look, Your Honor. I think it may in this case, but I'm not positive. I think it does, Your Honor. Yes.
All right. And Mr. Lanning, there's one more thing I need to tell you. Once you have completed, thank you. Once you have completed 1/2 of your original probation period, and if you would have completed all required programs, the probation department will notify the court that you may be eligible for early discharge from probation. If the probation department fails to do this, and you have not violated your probation in the immediately preceding 3 months, you may notify the court that you may be eligible for early discharge on a form provided by the state court administrator's office. Any questions about that?
No, sir.
Anything further from anyone?
No, Your Honor.
No, thank you.
Good luck to you, sir. Good luck to you, man.
Thank you so much, sir.
Right, I believe that concludes matters. So we will recess, right? People versus Brooks, 21-15620. Your appearances for the record, counsel?
Eric, can I host on behalf of people?
Good afternoon, Your Honor. Dwayne Burgess on behalf of Mr. William Brooks.
Your name, sir? You understand why you're here today?
Yes.
You understand that you previously pled no contest to the charges of domestic violence and assault with great bodily harm, with intent to commit great bodily harm less than murder. You're here to be sentenced on those 2 charges today. And Mr. Burgess is here representing you, is that correct?
Yes.
Mr. Burgess, have you had an opportunity to read and review the pre-sentence report and recommendation, discuss it with your client?
I have, Your Honor.
Are there any factual inaccuracies you'd like to point out?
No.
Anything you'd like to say on behalf of your client in regard to the sentence before I decide?
Your Honor, it was in the report, it's noted the guideline range of 0 to 6, no prior felonies, no prior misdemeanors. As you read the incident report, a fight between a couple of brothers who, at the end of it, would have gone on with their lives, but somebody called the police in the meantime. Mr. Brooks within the report indicated his acknowledgement of his fault in this case, drinking involved, and but for the drinking, we wouldn't be here today, I'm sure. Considering all that, there was an agreement in this case, Your Honor, that he be granted a 1-year delay if he successfully completes that probation, and a conviction on innocent assault and a domestic violence would be treated as under the deferral statute. So I would ask you to follow that agreement and that recommendation, Your Honor.
All right, Mr. Prosecutor, any corrections, deletions?
No, Your Honor.
All right, and your position on sentencing?
Your Honor, I'd ask that you follow the agreement.
All right, Mr. Brooks, anything you'd like to say about your sentence before I decide? All right. Well, Mr. Brooks, you're 23 years old. You have no record of any kind. Believe me, that's, well, I guess, given the people I see, that's kind of unusual. Probably are a lot of people like that out there in the street. But anyway, for someone that I see here, that's pretty good. No record of any kind at 23. Based upon the need to discipline you as a wrongdoer to protect society from these kinds of activities and the need to deter you and others from committing these kinds of offenses, but being hopeful that you have potential for reformation and rehabilitation. It shall be the sentence of this court in regard to both count one and to count one, which is a delay of sentence, 1 year delay. These are the terms of the delay. No alcoholic beverages, don't enter bars. No comply with any request by your probation officer or law enforcement for an alcohol test. Completed outpatient substance abuse treatment program if requested, and an assessment. How far did you go in school?
As far as 8th grade.
8th grade? What kind of work do you do?
I do farm work.
Farm work?
14 hours a day.
Okay. Well, farmers have to be smart these days, you know, and just because you don't have a high school diploma doesn't mean you're not smart. But you'll find the remainder of your life would be a lot easier if you could get a GED or a high school diploma. It would make your life a lot easier in the future. You're to waive confidentiality about any treatment program so that your probation officer can know how you're doing. You're not to engage in any assaultive, abusive, threatening, or intimidating behavior, nor use any object as a weapon or have any imitation weapons. You're to comply with any written or verbal orders by your probation officer. I'm eliminating numbers 10 and 11. Report any arrest or police contact or loss of employment, change of residence within 1 business day. Maintain employment of at least 30 hours a week. Do nothing to be terminated from that employment. Is it your family farm or are you working for a farmer?
I work for a friend's farm.
Okay. You're to comply with DNA testing and pay the $60 fee, pay $68 in state costs, crime victim rights assessment of $130, $30 a month oversight fee to the Department of Corrections, court costs of $250 at the rate of $15 a month, a fine of $500 at the rate of $45 a month, and repay the county of Tuscola $500 at $45 a month for your attorney fees. Any questions about that sentence? In regard to domestic violence, you are to undergo a 1 year domestic violence deferral status, subject to the following conditions. No alcohol, no drugs, cooperate with testing, substance abuse treatment if necessary, assessment if necessary. Same thing about a high school diploma, waiving confidentiality, no assault of abusive, threatening, or intimidating behavior. No, have no weapon or any object that looks like a weapon. Comply with written or verbal orders of your probation officer. I'm eliminating 10 and 11. Report any arrest or police contact or loss of employment or change of residence within 1 business day. Maintain employment of at least 30 hours a week. Do nothing to be terminated. $50 in state costs, court costs of $100 at the rate of $10 a month. A fine of $200 at the rate of $15. Any questions about that sentence? My duty to inform you, sir, that you are entitled to the appellate review of your conviction and sentence. This is done by filing a request for the appointment of an attorney to represent you, to file a motion for application for leave to appeal. If you cannot afford to hire an attorney to represent you on appeal, and you request an attorney, the court will appoint one for you. You may request an attorney by completing the request for appointment of attorney section that you will be given now, and return that within 42 days to the court. Today, we just need you to sign and date the receipt that you received this document. I don't suspect the half applies to these things. Because
I
these
don't-
are,
No, I
it's
don't
a,
believe so.
it's a
because
delay
an
of
assault
sentence.
crime.
And it's, pardon?
believe because it is an assaultive crime and a domestic violence crime that you cannot. That's stalking.
Anything further?
No.
Thank you, Judge.
Good luck to you, sir.
You have a scissor.
We're adjourned.
Not out here.